Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, everybody. Vince, I think that's probably because you haven't had it cooked properly. Eggplant, I've had it delicious before from a friend of mine. She cooked it. I was like, listen, I'll eat this because I love you, but I don't like vegetables like that. And then I was eating it. I was like, God, this is so good. Turns out she like salts it and like lets it sit for like a day ahead of time. It doesn't, it's not mushy. It's amazing. It's amazing. Hi guys. I hope everybody's doing well. Are you talking about me? Do I look like a geisha in this outfit? Memoirs of a Geisha was a really good book. I read that book. Yeah, it definitely can. Erica, I'm so sorry to hear that, but summertime? You hate the texture. It's the way she prepared it made it be really like harder and firm. So I'm all for it. I've heard of that. I've also heard of chicken parmesan, but I've never had it. Never really heard it in a restaurant either. Hi, Beverly. Not really. I think there was one honest to God, like StreamYard issue that wasn't me, but really no. Knock on wood. Let's keep that up. Yeah, so I guess it wasn't the Canadian internet. Actually, I did a speed test recently, and my internet speeds were like, my upload speed was like 840. I mean, I couldn't even dream of that before. So something's happened. Something's working. Anywho, you think it's amazing? Yeah. We don't. I've never really had it. I live in one of the restaurant capitals of the world. We have some of the most restaurants per capita here. There's almost always, yeah, I know, right? There's almost always somebody, like a new restaurant opening. That's funny. I like that. But not as many like standard Italian or Italian places as you would call them in America. Mr. Pancake, get on the ground. That is so classic. It almost sounds fake. Mark, you walked into me talking about Parmesan, no, not Parmesan. I love Parmesan, all cheese, but eggplant. Some people like it. Some people love it. Some people hate it. Some people tolerate other kinds of eggplants, if you know what I mean. And then we were being happy about the no Creed frames that we've been having lately. No Kitsch frames. Thank God, honestly. Hi, Sashina. Yeah, is it the meatloaf? Is that what it is, Vince? Is that like the standard? Well, we have to remember, I grew up on an island, a hippie island with a bit of a hippie mother. So I bet she made eggplant, but I bet I was meh about it too. But I was saying, Mark, that I went for a dinner with at my friend's house. She cooked eggplant. And of course, as a grown adult, I'm more respectful. And so I will eat what's put in front of me, and then I will deal with my feelings about it later. But it was delicious. And I asked her for how she made it, and she taught me. So you have to like salt it and then leave it in the fridge for a while, and all the water came out, and then it's quite firm. But I really do just need to say, hi, Tammy, Sashina's sister. No other Tammys. If your name is Tammy, but you're not Sashina's sister, I need you to disregard what I just said. That hi was not for you. That hi was specifically for Tammy dash Sashina's sister. Okay, perfect. I'm so glad. That's a good point too. That was probably a woman. Women don't care that much about size. I'm looking at a different screen that is not connected to this new one. That's not going to help me. Okay, before we get going, we are traveling down to Texas. We're going to go and listen to 2 cases in front of a judge that I've covered before. I believe it was on the first channel. We thought she was drunk. No shit. I swear to God. We really thought the judge was drunk. The vibe continues. But she also has figured out that people watch YouTube court. So without further ado, let's watch a little bit of this. Then we'll get ourselves into some family court. And go from there.
Calling cause number D1GN220000529, Cuellar versus Bluebonnet Electric Cooperative, Inc. This is another minor prove-up. Please make your appearances.
Your Honor, this is Guardian Ad Litem Stephen Lopez. I'm unable to turn on my video. There we go.
Oh, there we
Oh,
go.
good
Hi, how are you?
afternoon.
Thank you. I've got your appearance.
And Justin Dean for the plaintiffs, Arthur Cuellar, on behalf of minor A. Cuellar.
Joe
Thank-
Marcus on behalf of defendant Bluebonnet Electric Cooperative. Sorry for cutting you off, Your Honor.
No, it's okay.
John Mercero on behalf of defendant Karma Easton LLC.
And Arthur Cuellar here, father of Lisa Cuellar.
Okay. All right. Do you want me to go ahead and swear in Mr. Cuellar? Or do you have an opening?
I have a brief introduction just for the court's background.
All right, go ahead. I did read this, but
Okay.
benefit of the people out there and on live stream, you'd be surprised how many people watch these things, but go ahead, just, you know.
Actually, we're not surprised at all, Judge. Although I do think my YouTube channel has more subs than yours, but that's nothing. That's not saying anything. Thanks, Judge. I guess she's trying to get him to do a little explainer for us. All right, Stephen, what do you got? What do you got?
Read it about the
Okay.
poor baby falling off her bike onto a but go ahead.
Yes, Judge. By way of very brief background, on May 11th of 2020, 4-year-old Alicia Cuellar was riding her bike in her neighborhood when her bike tipped over and she fell on some metal grating that was surrounding an electric meter there in her neighborhood, and she injured herself. She received some bruising and some cuts to the top right part of her face. I've met with Mr. Cuellar. We've discussed Alicia's injuries. It's been about 4 years. She's recovering well. She does have a small scar, or a pretty good scar, I would say, above her right eye. But she's a normal, happy, healthy 8-year-old, and we're happy that she's doing well. The parties have entered into a settlement agreement, and I can give the court the number, or I can address those with Mr. Cuellar.
Okay, let's just go ahead and swear him in then. Okay?
Okay.
Mr. Cuellar, will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth by penalty of perjury?
Yes.
All right, thank you. You
Hi,
may,
Mr. Qu-
you may proceed. Thank you.
Hi, Mr. Cuellar. Can you please state your full name for the record?
Arthur Cuellar Jr.
Are you the father of Alicia Cuellar, who was injured in an incident on May 11th, 2020?
Yes.
And have you participated in a lawsuit that you brought against Bluebonnet Electric Cooperative Inc. and Karma Easton LLC on behalf of your daughter Alicia?
Yes.
And have you reached a settlement agreement in that case?
Yes.
Do you understand that by way of settling this case, you are waiving your child's right to a jury trial?
Yes.
And you understand that if this case had gone before a jury, you could have gotten more or less or the same amount from a jury?
Yes.
Okay. Is it true that you have entered into a compromise and settlement to settle this case for $64,000 for Alicia?
Yes.
And you understand that after attorney's fees, expenses, the net and medical bills, the net going to Alicia would be $30,000. $30,687.56.
Yes.
And you understand that Alicia's bills are being paid out of that $64,000.
Yes.
And are you satisfied with the money?
Holy shit. Mikey, she's getting $64,000 because she fell off her bike when she was 4 years old. Also, thank you. You're so sweet. That's a lot of money. Oh my God. That is a lot of money. Now the question will be, how much money will the attorneys take for getting her $64,000 for falling off her bike? Oh, Sashina, you got $50K for a 6-mile-per-hour car crash? Is that like 10 or 15 kilometers? I don't know. I don't know. Probably. Mark's guessing 33%.
Being divided up in that manner?
Yes.
You also understand that your attorneys are asking the court for fees of 33.3% in this case, which amounts to $21,312.
Yes.
And do you agree to those fees, and are you satisfied with the work you're?
Ding, 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 ding. You got it. Oh my God. Good guess. And yes, it should go to a college fund, right? And yes, Mikey, we know YouTube Daddy is a fickle master. You got $60K from no lighting at the entrance of a building. Whoa, Mimi. Damn. I have a hard time believing that. No, I'm just joking. That's awesome. You're amazing. How'd you know it? That's high. That's high. I mean, get it, right? Lawyers get it, but damn. Oh, and that's terrible. So that's not good. Hi, reseller. We are just listening to Judge take the proofs for this agreement. 4-year-old fell off her bike and she's getting $64K. YouTube is a pimp that we both have. Yeah, we trauma bond over that sometimes, don't we?
Attorneys have done in this case?
Yes.
Okay. And are you asking the court to deposit that net amount that goes to Alicia into an interest-bearing account in the registry of the court?
Yes.
And you understand that once that money is deposited into the court and the judge signs this final judgment, that the case will be closed and no money Alicia will not be able to ask for more money from this case?
Yes.
Is Alicia currently undergoing any medical treatment related to this incident?
No.
Okay. And she doesn't have any ongoing medical needs related to this incident, does she?
Not currently, no.
Okay. And you have signed confidential settlement agreement and release in this case, correct?
Yes.
And you've had the opportunity to review that with your attorneys?
Yes.
Okay. And you've signed that release of your own free will?
Yes.
And you believe that the settlement and compromise is in the best interest of your daughter, Alicia?
Yes.
And are you asking the court today to sign the final judgment to memorialize and to make official that settlement?
Yes.
Okay. That's all the questions I have, Your Honor. If the defense wants to clean anything up that I missed, go ahead.
Thank you. Anybody else have any questions for Mr. Cuellar?
I don't have any questions, Your Honor.
I do, Judge. Why is there a guardian ad litem in this case? That's why I have a question. Is that standard? Does anybody know? To appoint a guardian ad litem? Because that's what so there are 4 attorneys, 1 judge, 1 dad, possibly more dads, and me. This judge, oh, Mark, honestly, I really want to find the footage of the drunk hearing, because I swear to God, she was drunk. It was almost concerning. But she preens a lot. Actually, did we think she was drunk or high? Allegedly. All of this alleged. All of it alleged. All of it. She was taking some little breaks off the camera and then coming back on all ready to go. And yes, because it's a baby. I guess so. Hi, Mayor. Guys, Mayor posted the link to Sassy's memorial. It's coming up. I already set my notifications for that on YouTube. You can do that right away. So please check that out, and the GoFundMe, if it's still up. If you can pop that in the chat, Mayor. And know it's hard coming up, but we are going to be there for you. And I would hope that this is why any reward would go to the child and not the parent. But it just seems like an interesting case for an ad litem. You know? Did you get $65,000, Jelly Beans? 64,000, sorry. Fucking get it right, Paisley. Would you? You're so confused how they awarded 64. Well, they didn't award it. They came to an agreement, and it's possible that they could have gotten better, worse, or the exact same if they had gone to trial, but they didn't. They came to this agreement. The 2 gentlemen on the bottom here, Joe and John, the 2 J's, J and J, they are the lawyers for the electric company, I guess. And then the top lawyer, Justin, is Dad's lawyer. And then Stephen is the guardian ad litem. And then Judgy over here. And believe me, you'll see. Anyways, after this, she continues to talk and just be terrible. So, allegedly.
No question for me, Your Honor.
None from me, Your Honor.
Okay, the court is going to approve that. And thank you all again. And I hope AC, I can't remember her first name, but I did.
It's Alicia. We just talked about this. They just said it. How do you not remember her name, Judge? I remember her name, and I just took a huge hit off my vape pen, which is legal here.
Poor baby. Alicia, poor baby. So I'm glad this worked out, and maybe she's, it'll fade with time, or can get a little plastic surgery or something, but I'm sure that was very distressing. And, but anyway, so thank you all so much for settling the suit in her behalf. And, we will sign off on that. Who is going to send the judgment to Miss Latham?
The judgment has been emailed to the email that we got, and it's also
Oh,
in the
great. Great, okay.
If you
So-
sent it to Miss Poe, she's out, so you'll need to send it to Allie Latham. I have not received it.
You were CC'd. Let me make sure you're on that.
Yeah, that maybe something
What is she
funky going on.
doing?
Sometimes
You know what?
What
Never
is that
mind. I see it. I
position?
had it checked off for the other case. Sorry about that. I see it.
Okay, yeah, I just sent it when I heard you requested from the other party.
great. Oh, well, that's, on the fly, thinking on your feet. Thank you so much.
Okay, thank you,
Good
Judge.
luck to you, Mr. Cuellar, and to
Thank you, Judge.
Alicia. Y'all enjoy the rest of your week.
Thank you.
Thank you.
Thank you, Your Honor.
Ostensibly, they could go out for dinner this week, I guess.
All right.
So now it's going to be really awkward, you guys. This is an example coming up of how attorneys have to sort of pander to judges because they're essentially judging them. And this was not a funny story. There's nothing funny about it, but it is, you're going to cringe. It's cringe-worthy, cringy, cringe. You'd think she'd know the secret. You want your camera up higher than you, looking down so that you get the better angle, Judge. You don't want to be above the camera.
All right, so we have an agreed order on this. Gosh, we probably should have done this one first. The motion to consolidate, Rivera, the Coliseum versus the Coliseum. Ms. Romero and Mr. Conch. I'm so
Yes.
sorry.
It's okay, Judge.
Oh my gosh, because I had written on there agreed in really big writing, but we took other stuff first, and I'm really sorry. I guess
Well,
I can.
I got to hear International Shoe argued for the first time in a long
I
time,
know,
so
right?
I'm happy about that. It was worth it.
Like the third time in 3.5 years. So, and then the first one is so funny because the first one that I had, it involved as far as I know, I haven't been reversed, but it involved somebody who bought or paid for a Airbnb from another, state, I think also California. And then like there were all these travel restrictions, so they couldn't go. Like it was right during COVID. And so, but nobody provided any, so I took it under advisement because nobody provided me with any citations. Even International Shoe wasn't cited in the motion. So I was like, wait a minute, I think I remember something called International Shoe. So I was like, so I took it under advisement, and I was kind of like, I don't know if you remember those cases from way back when, like if you didn't brief something adequately at the Court of Appeals, they dismiss your case for inadequate briefing. And I was like, why am I doing all this independent research to see if an Airbnb person who advertises in Texas has met minimum contacts under International Shoe? And I'm just like, inadequate briefing. It's like, because I don't know, and is it really incumbent upon me to find that out and do all this, I don't remember. I just didn't think it was fair that they were just like, too bad, so sad. We're going to come into Texas and advertise our house. But, there was it was during the time where they had locked down all the airfare and everything. You couldn't fly into like wherever they were. So as far as I know, nothing has happened with that case. But it is interesting, isn't it?
Absolutely.
Okay. Well, I just thought that was that. And then that one had the little wrinkle of the individual capacity thing. Like, how are you going to say this woman who knows what she does for them? She was probably just tasked with setting up this event, and then you're gonna say she's on the hook for the whole thing and she doesn't even live in Texas? Or, the company is not, formed here and she's not a registered.
She's talking about a case she just heard. I don't think it's appropriate. And Mark's got the giggles. I love it. The attorneys look scared because they can't cut her off. They have to talk to her. They have to defer to her. This is exactly what it was like in the last hearing too. She sounds a little bit fucked up. They have to laugh like the judge is funny. And remember, do we recall what she said at the beginning? Oh, we should have taken you guys first. I've basically wasted your time because you are in agreement. And then she proceeds to talk about that shit.
Registered agent and all this, and I'm like, I don't think you got minimum contacts, sir. Okay, we're a bunch of legal nerds. Okay, let me call this case.
Hold on, did she miss?
D1.
Hold on, did she miss? Look at her hands. Did she miss her little clap there? I know we don't want to really go back, but I'm pretty sure she missed her little clap there.
A registered agent and all this, and I'm like, I don't think you got minimum contacts, sir. Okay, we're a bunch of legal nerds. Okay, let me call this case D1GN23.
Rose, at the beginning, she acknowledged that we're on live stream. She actually asked an attorney to do a little explanation extra because she said you wouldn't believe how many people watch these. I don't know if she knows we're here. If she does, leave a comment, send me an email. I don't know. Let's let her finish this case.
0009 the 30 Rivera et al. Versus the Coliseum. This is a agreed motion to consolidate. Please make your appearances.
Good afternoon, Alyssa Romero for the plaintiffs.
Thank you.
And I'm Tyler Koch for defendant the Coliseum Inc.
Thank you. All right. So I'm
the Coliseum? Not the Roman Coliseum, I'm assuming. Bye, Mimi. Thanks for being here. Could you imagine? Wouldn't that be fucking epic? I sometimes wish, no offense, Americans, and there are famous places in America, but could you imagine if this was some case about the Roman Coliseum and this lady was fucking in charge of it? It's ridiculous.
I'm just assuming. I did read about this case and I appreciate all y'all's hard work on it. I'm sorry you had to wait an hour to be heard on an agreed motion. And then also suffer through, a discussion of international shoe. But anyway, it was good to see y'all. Do you want to show me the agreed order? Does anybody have, because I think the issue here for people that may be watching is that this case was being prosecuted. It's a motor vehicle accident. I think with
she just said accident, Mark. I hope that wasn't an accident. Accident. Oh my God, you're so sweet. Thank you so much. Oh my God. I really hope we don't run out of people to give memberships to. I am so thankful and so excited. Please make sure you have gifting turned on. Who the fuck is texting me? Can you guys hear that? Thank you. I don't have a button. I can't say it like that. Amazing. We did members only yesterday. We watched a bit of a crazy, risque show in a movie theater, a body cam, and I tried some candy that was spicy. You have your own Coliseum in Vegas. You also have isn't there an Eiffel Tower in Vegas? I've been to the Coliseum in Rome, the real one. And is she talking about us? Is that what's happening? I hope that's true. But if you do become a member, thank you so much. And thanks to Mark. And Jim, oh my God, 8 months. Almost a baby. Shirtless dad. It's okay. We don't even have the rule of like no shirt, no shoes, no service here. You're allowed to be naked, butt naked if you want. Is that it, Vince? We have to find that other case that I did. We should rewatch it one day. It was long. It was the lesbian case. Remember, it was about 2 lesbian parents and they were having a fight over the custody, weren't they? Was that it? I'm pretty sure that was it. Oh, all the deets now. And see, that's allowed. Who the fuck? Okay, I gotta check my phone. Thank you again, Mark. Amazing.
It's a dram shop case as well, and the motor vehicle accident did result in a death. And so I'm so sorry for everybody and that family. But anyway, there is another case involving the same people, the same plaintiffs and defendants. And so these parties are only seeking to consolidate these 2 cases into one. Is that correct?
Yes. Well, the other case has a different plaintiff. I believe the other individual in the accident where my client crashed into, but the same causes of action against the same defendant and the same type of cases. Yes.
But you do have
we remember the drunk case with this judge where we thought she was drunk. I'm sure MB was there. We just watched a settlement, MB, and I wondered about the appointment of a guardian ad litem for a youth in a civil lawsuit. I found that interesting. Does that money come out of her settlement? Anyway, she got $64,000 for falling off her bike when she was 4. You've appeared before her several times. And is she always like this? MB's like a celebrity. Is she always like this? Allegedly. She acknowledged us in the beginning, MB. She said you wouldn't believe how many people watch these live streams. I think she's talking about us specifically. Again? What in the fuck is going on? Also, did I miss somebody's little chatty chat? Carla, aw, we're so glad you're here. We love you too. And Jim, no, I got Jim's. We talked about it. 8 months, almost a baby. Yeah, we got that. Okay, we're good. I know, and she is. Oh, she's always like this. Yeah, elected, right? An elected judge. I think that's the only way I can explain it. I don't know. I guess I'm actually assuming she's like, oh, she was a Republican and then switched to Democrat. So funny. Our brains are so similar, MB, because I was just thinking, I bet she's a Democrat. And that's not to be rude or to throw shade at either or. But mostly just like I probably would be considered a Democrat in the States. And actually, no, what was I considered? I went on a trip to Houston and anyways, that's a whole nother story. But I just thought it would be funny. I don't know. Did she? No, I don't think she's just eclectic, you know? If anything, I think it's pills. If anything, I think it's pills. Alleged. I think she's nice too, but just some things are serious, you know? Everything's out of whack.
Agreement on that.
We do
That
have
is
an
correct, yeah.
agreement. I don't think we have a drafted order
Yeah, we
yet,
talked about that.
which we can draft and file.
I remember talking about that.
Okay, well, do you
Oh
want
my
to just,
fucking God.
the court's gonna agree, you know, that's not out of I mean, that's right in there with the law. So if the parties agree with that, the court would agree and would sign that order. Just draft it up and copy Mr. Coke. Is it Coke?
Yes, Your Honor.
Okay. Copy Mr. Coke and send that order to Miss Latham or vice versa, whoever's doing the drafting. And we'll sign off on it.
Okay, I appreciate it.
All
I'll
right.
go ahead and draft that, Tyler.
Hey, I'm gonna have some eyes out for y'all. Like next time you're gonna jump the line. Okay?
Just look
Sounds
for my
good.
pink room.
That's right. All right.
Thank
Thank
you
you
so
so
much,
much.
Thank you. Have a good
MB,
day.
though,
Okay,
here's
you
the
too.
question. Do you have to smile and like laugh in front of her? I think you do, right? Because I think that's sort of what you have to do. Because she's sort of your boss for the minute. Yeah. That's just the way it's got to be. Which that's why I love you people, because you can leave. Oh, that's my theory too. You know, when your boss, when you laugh at your boss's jokes, are they funny? I think is it Austin? Is it Austin? I think it's Austin. Anyways, I did go ahead. I have another case, but it cut off in the middle, so we're not going to watch that. We're going to go over to watch Judge Kirkham. Give me a second. I don't even think I will frame when I pull this up, but let's hope. Don't care much about the destination. That's where I'm gonna be. He does have a bit of a crooked receding hairline. All right. Judge, Wordle is over. Wordle time is over. Oh, by the way, almost all of the cases in protection order court today got transferred to Superior Court. It was annoying.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2009-467 DS, Sade Holmes versus Brock Kennedy. Today is Monday, July 29th, 2024 at 8:57 a.m.
Court will note the appearance of Mr. Carroll on behalf of the plaintiff, Mr. Scott on behalf of defendant. This matter is before the court on the defendant's objection to motion to a motion to set aside the referee order in this particular matter. Court does note I have received the answer. Mr. Scott, you can proceed.
Yes, good morning.
His name is Kel Scott, K-E-L Scott. And I think it's not a dining room table. I'm pretty sure that's a conference room at a lawyer's office. Just in my experience, most homes even with big long dining tables don't have black leather business chairs as the seating. That tends to be a lawyer conference room type of thing. But I like how your brain defaults to the table. It is a weird setup. I think they've just given them, separated him. He's in his lawyer's office, but he's not within earshot. So you think so? I actually have to do some research because I want to listen to one of the cases that I heard today. So I'm going to have to do some research about getting to Superior Court. Whole nother ball game. And what is Kellen Brock? Is that his name, Brock? Oh, Brock with a C, no K. That's weird. That is weird. Oh, I know, Lucy. I know. Hi, Peter. Welcome. The black office chairs, yeah. Don't you want people in your kitchen? You'd think in a office environment you'd want uncomfortable chairs to have business negotiations be done quicker, right? Actually, that reminds me of when I worked at many places, but one of the bus companies that I worked for, they did a stand-up meeting in the morning, and like that was what it was in my calendar as. And I remember going to it and I was like, what is this meeting? Like, what's the point of it? And they're like, oh, this is a stand-up meeting. We stand up so that it goes faster. And I'm like, what? They're like, we have the meeting in this room, but we all stand up so that you finish like faster. And I was like, wow, I didn't realize that standing up made everybody finish faster. And then they sent me to HR instead of the stand-up meeting. So yeah, I remember that part now.
Morning, Your Honor. Thank you. Your Honor, I point out at the beginning of the motion, I presume the court has read that the court rule MCR 3.215 does provide that the referee is supposed to provide findings of fact as well as rationale for the decision that did not happen. Makes it really difficult for us to presuppose what's in the mind of the referee. So I think
No, you're breaking up, Mr.
alone,
Scott.
it would be set aside a bull. But with that said, Your Honor, can you hear me?
Yeah, we can now. You were breaking up a little.
Can you hear me okay?
Yes.
Okay, thank you. With that said, Your Honor, the referee did put together a number for the income for the plaintiff as well as the defendant. And it's the defendant's position, obviously, that those numbers are not supported by the record at all. First of all, the court concluded basically that the defendant had
This is all him. This is all him. This is all him. Not me.
$388, that amount of money. And the only that money is if you presuppose evidence that isn't of the record. I mean, Mr. Kennedy provided 2 pay stubs. His income is about $38 per hour. He provided 2 pay stubs that showed that he had 30 hours of income. So according to Mr. Carroll, he should be somehow imputed with 80 hours every 2 weeks or full-time 40 hours. It just doesn't happen, especially in light of the other testimony that is evidence, not speculation. Mr. Carroll's suggestion that he should have $80,000 of income based on full-time employment is pure speculation. Mr. Kennedy testified, as I put in the motion, that he has periods of unemployment where he's not employed. And even Mr. Carroll, in his questioning of Mr. Kennedy, pointed out that during the whole month of February this year, 2020.
Paul, I have to make a public apology because we are still using StreamYard and now we're not having any problems. And I was just boasting earlier about my 840 megabyte upload speed earlier.
Before he was unemployed. So there's no way that you can presuppose that there's going to be 40 hours per week when the evidence doesn't show that. It shows exactly the opposite of that. What you do have, Your Honor, is what Mr. Kennedy earned last year, and that's $59,266, which is proven by his W-2s, and there is no refutation to that. And Mr. Kennedy's testimony at the hearing that he is not going to earn $59,000. He wouldn't expect to earn $59,000 this particular year. So while it's true he's changed jobs, it is not true that there's 40 hours a week available to him. And so therefore, there is no evidence that he's going to have $80,000 unless we do, as Mr. Carroll objects to, purely speculate.
MB got it for me, so I don't sound like him. Oh, and it's a joy. Oh, it's so annoying.
That
Mr.
he
Scott,
has 40 hours per
you
week. So at what-
you broke up and we didn't hear the last part of all of that.
Okay, thank you, Your Honor. What I said was, I would ask that you assess his income at $59,000, not $80,000 as the referee had indicated. That's what the record shows. That's what the evidence shows on the transcript that's before the court. Secondarily, the plaintiff's income is skewed low. Mr. Kennedy's is skewed high. The plaintiff in this matter submitted a motion to this court. And when she submitted the motion, she said that her testimony was, when she submitted the motion, that she earned $33,610, which is supported by her W-2 statements. The referee somehow finds $25,000.
Oh, poor guy. It sucks, my sir. It really sucks, Cal, but you're a lawyer. I don't know what computer he's using. I could recommend a good mini PC for him. So what he's saying basically is he makes $38 an hour, but he don't work 40 hours a week. How many does he work? I mean, I'll say if you have a job that you have 38, if you work 38, if you get paid $38 an hour at a job, you should do probably all you can to keep that job and increase your hours there, right? Sounds like a good job to me. If you're the working type, you know, some people are into working, some people are not.
Okay, Mr. Scott, you're not having a good connection. Because
$71
you're
is her
breaking up.
income, and it makes her even come. But with that, yeah, it doesn't look like I'm breaking up, but I'll maybe just get closer to the computer, Your Honor.
Okay, yeah, you were breaking up. We were only hearing a very little.
Okay, maybe if I'm talking a little slower too. The recommended UCSO was $25,571, Your Honor. There is no record of that. Her own motion under that she signed said that she made. Are you able to hear that?
No, it broke up again. So I got the gist of what you're saying. Why don't we let Mr. Carroll speak?
Well,
And I have reviewed your answer, Mr. Carroll.
One real quick thing, Your Honor, just to supplement this record. She did testify specifically that she doesn't report all of her tips, that somehow she just doesn't have to report them on page 10.
She like somehow doesn't have to report them. Wait, if I get closer and slow my speech down, does that help technology? No, but seriously, it's pretty common for people that get paid tips to not always report them all. Oh, Lucy, if Judge Webster was back, I would throw a party. I would throw a party on the channel. I miss him. Judge Baker ain't cutting it. Oliver Tips. Tips with a P. You like the P.
10 of the transcript. And she said on average, she's making about $700 to $800. So in addition to the $33,000 that's reported on her W-2, she has additional tips that she admits aren't reported. Now, I estimated those, but it's certainly $700 to $800 when she is working, and 50% of that is her W-2. So I apologize for adding, and I appreciate the courts allowing me to do that.
Okay. Okay, Mr. Carroll, go ahead.
Judge, as to his income, I just took what his wage was per hour. I attached to the court his W-2. If counsel says he only works 31 hours a week versus 40, he didn't tell me that he didn't work 40 hours a week. This is a new job, and he only had 1 month off in unemployment with his last employer, and clearly indicate on the record that they use tarps and salamanders to heat the jobs because they're doing masonry work. And I'm sure the court has witnessed, just as I have, guys that do brick work, they work all year round. If he has unemployment this next year, I suppose we can look at it then. But right now, we don't know if he'll have it for this particular job. His rate is $38.52 an hour. If counsel's saying he only works 30 hours a week, then maybe I guess we take it at 30 hours a week versus 40 hours a week. But he didn't tell me he couldn't work full time, and we also know he has a second job of his own, of which he testified, claiming he didn't make any money, yet he wrote off about $14,000 as transportation expenses. As to my client's income, she guessed at best.
Yeah, it's a 1099 for an independent contractor, I assume, for people working in the United States. What did they send me? Oh, a W-8 BEN, I think I have to file. No. I'll find out next year.
What counsel didn't consider is that she also has to testify that she has to tip out her other employees. She's only seasonal at the Duck Lake Country Club. It's 5 or 6 months out of the year, and the other place is only 15 to 20 hours a week. I'll agree that the front of the court, for whatever reason, used a number less than what my client's W-2 was, because her W-2 for the two places for 2023 was about $33,600. So if we took him at 38.52 times 60 hours for 2 weeks, I guess, instead of versus 80, I guess I'm unhappy with that idea. And her at 33,610. Ultimately, her income is also presumptive too. She's presumed to have made 12% on every table that's credit card, no matter what. Whether she made it, if the person left her a dime or left her a dollar, she has to take 12% of her credit card sales. So, I mean, that's just the reality of waitressing. It's kind of sometimes you do better, sometimes you do worse. Not something that is always reported, because the employer takes 12% off the bat right away, whether you made it or not. And that's cash and credit card sales. That's sales for the entire day. So ultimately, Judge, if we can't resolve it here, I suppose we have our hearing in October, and the court could take testimony at that point about incomes. But I think the front of the court did the best they could with the circumstances. I've seen reports come out from Calhoun County just like this on a regular basis. I guess I've just never faced an objection.
Okay. Mr. Scott, it looks like Mr. Carroll is proposing they use the 33,610 for his client, and your client, the hourly, at 60 hours every 2 weeks. That's my understanding. Is that your correct proposal, Mr. Carroll?
That's correct, Judge. That's what I have as far as his paycheck. Paycheck.
Is that agreeable, Mr. Scott?
Just a minute. I don't even know what that calculates out to be. So,
well, I don't care what it calculates out to be. I can't believe you're arguing for less than 60 hours every 2 weeks.
Oh, Judge! Oh my God, he's savage! Oh, he's savage! Did he just laugh and say, I don't care what it adds to? Oh my God. And he's right. I'm sorry, if you're gonna work 30 hours, work 40. Right? Most jobs in Canada are 37 and a half hours. I don't know why. I think it has to do with some legality, but almost every job, most of the government jobs or union jobs I've ever had were 37 and a half hours a week. But they didn't pay you for your lunch. Some of them don't pay for, there's a whole fuck up. I don't like it. I don't like it. I like my boss now. She's psycho, but she lets me sleep in when I want.
That'll be acceptable, Your Honor. I think that's a fair proposal based on this record, as well as the only thing on the 33,600 is we know that she testified that her tips aren't included in her W-2, whatever they are. So it has to be more than 33,610, Your Honor.
He made a proposal. Is it acceptable or not? I'm not going to argue about
what
minutia on this point.
I can't without talking to my client. I can't make an agreement for him. It's a proposal, and I'll ask my client if I have an opportunity, Your Honor, if I can have just a minute. Unless Brock, are you in a position to have a position on that yourself without talking to me? Are you okay with 33,000 being used as the number? Because that's $59,280 to you, and that would be 33,600, but it's not going to include any of her tip income.
I would like to discuss that with you, Mr. Scott.
Okay, what I'm going to do, we're done. I'm going to refer the matter back to the referee for specific findings, and then we'll have to address it at that point if we need to go further. So,
Judge, if I may, as a housekeeping matter.
Go ahead.
And I'm sure the court probably doesn't, when it comes back to these show causes, we dealt with this once before when the front of the court had set a show cause on the parenting time issue. I think it was like July 13th. We spoke when by telephone. I had a phone conference. We got another notice from the front of the court setting an evidentiary hearing with the front of the court referee on August 19th of 2024, which is because, and I'm not saying Mr. Scott's client's doing anything wrong. He continues to file improper parenting time objections, so they automatically kick out the orders, and they either get signed by you or they get they stamp your name, Judge. I don't know. So I'm just, for housekeeping purposes, it doesn't make sense to do that hearing since we're set October 1st.
This was one that was signed by you, Your Honor. So I thought that you may have wanted to hear what the actual reasons were, but
no, these come automatically, and then the court signs those orders. So I will, if you want, Mr. Carroll, you can basically send in a order to again have all of those.
Welcome, Knox. Judge Grumpy Pants is being a little grumpy, but we're glad you're here. We're pretty friendly. Ask any questions you might have.
Show cause is heard in October at that particular hearing, and then we'll just proceed on that. And if you do get an agreement between now and then on the support amount, then we can address that at that time too.
I will confer with Mr. Carroll immediately, Your Honor, on trying to resolve it short of an additional referee hearing.
Okay. Thank you. And I will do the order referring it back for specific findings.
Thank you, Judge. Have a good morning.
Thank you. So
will he salvage it? This video, we'll see what happens. Oh, look at that art. It reminds me of a 1990s doctor's office. Not the one up in Anya's. That reminds me of 2011 Pinterest. Just a little warning, this lady's voice is annoying, so be prepared. She won't call the case. Also, people, get your lighting right. Rebecca, come on now. Why so dark in your face? You see how I'm lit in the front?
Does your client plan on appearing this morning?
Your Honor, unfortunately, my client is in the middle of work travel right now. If the court desires him to be here or wants him to be here, we are agreeable to an adjournment. This was set without prior notice to us. So if the court wants him to attend, I'm certainly happy to, I guess, request an adjournment. But if the court's fine moving forward, we can do that.
No, we can move forward.
Calling
Okay.
case 2011-2274DS, Rebecca Fletcher versus Paul Franzman. Today is Monday, July 29th, 2024 at 9:11 a.m.
Court will note the appearance of Ms. Henderson on behalf of plaintiff, Mr. Todd on behalf of defendant. This matter is before the court on the plaintiff's motion to allow witness to testify. In this matter, the court has reviewed the pleadings, and that includes the defendant's response and answer in this matter. So I guess I'd rather have Ms. Henderson, rather than reiterate everything in your motion, respond to Mr. Todd's answer.
Sure, Your Honor. Mr. Todd relies in his response to our motion in the Sermon v. Sermon case. In that case, an 11-year-old child was allowed.
Watch it, Anya. Also, not you, Rebecca. Sorry, I was yelling at the other Rebecca. I forgot that I'm sure a few Rebeccas are watching. Why is the light so terrible here? And what is she gonna say? We did see her once recently, Lucy. I saw her off in the corner, only a little bit. We did see her. She got a little bit of that Ozempic jawline, hey? What do I know? I don't leave the house.
Allowed to testify regarding allegations of abuse. In our case, the child is 13 and a half years old, and she is the only person that can testify to how she is treated at her father's home. We have included some of the potential testimony in our motion, specifically how she hears her dad's badmouth her mother in front of her, how she's treated in his home, his excessive drinking, among other things. We had an expert witness in this case, Ms. Katz, weigh in, and she stated that although generally she would recommend against it, in this case, she thinks that testimony may not only be not.
I don't know, because she's 13. He might say yes. I've heard him and other judges say below 13, they require both parents to consent, but above that age, they will do it sua sponte, I guess, or like on one parent's direction.
Detrimental, but it may help Macy's mental health. We have listed her on our witness list. She has been sequestered during all of the proceedings, Your Honor. This court has allowed minor children testify in parenting time disputes. Previously, this is not a custody motion. That is correct. So in-camera interview would not be appropriate at this time. We're simply asking that Macy be allowed to testify as to what she has witnessed, and a lot of those things are the things that only the child can testify to reliably, Your Honor. So we're asking that with certain precautions that I was going to request the court to make, such as having the parents off camera, the court allow the child testifying in the next court hearing prior to the court making its ruling.
Okay, thank you. Mr. Todd?
Your Honor, in this particular case, the record has already been closed. We believe at this point, this request is, the plaintiff's attorney has rested and closing has been made. In essence, we are simply waiting for the finding, which has a hearing scheduled already. And it's not accurate that in Sermon the child was 11. In Sermon that child was 12. And the court specifically found that for a custody dispute, where there is an allegation of abuse and CPS involvement, that the child could testify there. That's not the situation we are in. This is simply a show cause motion, in essence, a series of show cause motions. There is no allegation of abuse. There is no CPS involvement. We believe. Additionally, it's a mischaracterization of Ms. Katz's test that it would be beneficial for the child to testify. Really, the testimony was that the child felt that she wasn't being heard. And we believe the most appropriate forum for that is counseling. We believe it would be detrimental to the child, detrimental to my client in terms of trying to continue to facilitate the relationship. Additionally, the referee has all the hearing facts and determined that this would be cumulative in nature. We also have concerns that in the event that the court allows the child to testify in this particular case, it would open up child testimony for virtually all hearings. In which case the person who has the child would simply need to tell the child, hey, go and testify poorly about the other parent and you can stay with me. And so we are respectfully requesting that the court defer to what the referee did in this matter and deny plaintiff's motion requesting that the case be reopened in essence to allow the child to testify.
Okay, thank you.
Your Honor, did the court have a chance to review the transcript? I ordered the transcript of that particular portion of the testimony, and I have attached it the same day that the motion was filed.
I went through the referee's findings, et cetera. Yes.
Thank you.
In this matter, the court notes at page 10 of the transcript, the referee acknowledges that Macy would be allowed to, testify. There'd be no prohibition based upon her age or anything else. Although the referee did state that Ms. Katz delineated all of the, concerns and issues that the child had in her testimony, and he said it would simply be cumulative of her testimony. He states at page 10, the referee, I don't believe that there's anything the child's going to, I think he meant going to bring into the record that would help me to understand what I need to figure out in determining whether or not there has been contempt. Court will note that Michigan Rule of Evidence 403 does provide that the court or the referee can exclude cumulative evidence, and I think that's clearly what the referee referenced in this particular matter. The court notes, as Mr. Todd points out, that the plaintiff had rested, that there in fact had been rebuttal testimony, closing arguments, and simply awaiting the finding in this matter. The court does not find that the referee committed a factual or legal error in this matter. He has the right to bar cumulative testimony, and as a result, the court will deny the motion in this matter. Mr. Todd, you can prepare the order denying the motion and submit under 7 days.
Big D.
Free to go. Have a good day.
Big denied. Oh shit. But here's the thing. The child already talked to the referee. Big D. Love it. Also, if you're telling me that you're watching me in Ghana right now, Norbert, that's blowing my mind.
Calling case 2000.
Do you think Miss McNiff thought that she would be in Africa on somebody's phone? I don't think so. I'm excited. Good night, Bill. We're having a worldwide night tonight.
32760S, Brittany Seifert versus Benjamin Seifert. Today is Monday, July 29, 2024 at 9:18 a.m. We do not have plaintiff Brittany in our waiting room.
Court will note that Christopher Engelby is amazing. Thank you so much, Chris. Denied. That's right. Denied. Denied. Let me ask you something. The child's not going to testify. I know, Vince. Norbert is a romantic. I'm loving it. Let's see. He's already in a piss off mood. I'll say that. So let's see how he treats Miss McSniff today. Can you imagine like that Judge Madeline having a docket like this? Busy?
Note the appearance of Ms. McNiff on behalf of the defendant in this matter. The plaintiff has not appeared. I note, Ms. McNiff, the issue in this matter is pretty clear that whatever was prepared, I don't know who prepared the order, that you switched the plaintiff and the defendant. Is that correct?
Well, there were two issues because I have to come back every week apparently on this case. But the issue was the plaintiff and defendant were incorrect, and also I filed the order to cease child support under the ROPA case and not under the DS case. And friend of the court wants it under the DS case.
Okay. So you're gonna have to refile, is that it?
It's looking like that.
Okay.
I would prefer to get this done. As much as I love seeing you every week.
Hold on.
FOC filed an objection because the plaintiff and defendant were transposed. I think, wasn't that the only objection, was the plaintiff and defendant were transposed?
Well,
Last case?
there was
He's
an
like my roommate.
objection because we had filed under the wrong case. We filed under the ROPA
Right.
case and not under the support case. And so then but those two cases have different plaintiffs and defendants. And so
And so we say, thank you, Christopher. I hope that there's enough people that have signed up. Thank you so much. So much.
fix the case number. She didn't also fix the plaintiff and defendant issue.
Well, with that, I don't have any problem with correcting it and switching the parties back, but if we've got different parties, I think you just need to refile. Because otherwise, it can always be argued that somebody didn't receive proper notice, et cetera.
I'm fine with that, Your Honor.
Okay. So just refile it and we'll get it taken care of.
Thank you.
Thank you. Have a good day.
You too.
Right, I sent that order to you, Judge.
Love you, Chris. You know what? I was thinking, you guys. Oh, he's just gonna dip off for a minute. That's fine. I'll talk. I was thinking if we had any old Judge Maribel, I would love to react to some of that. We gotta find some of it. What am I gonna do? How long did they wait for? Fucking long time, baby. The rest of the time? No, they came back.
And we have
dismissal already.
Hold on, Butzel.
Calling case 2022-2530 CB HAB Joint Ventures LLC versus Matthew Lavender et al. Today is Monday, July 29th, 2024 at 9:40 a.m.
Could we get the, I note the attorneys have changed. Could we get the appearance of the attorneys, please?
Good morning, Your Honor. Tyler Burke appearing on behalf of the plaintiff, HHB Joint Ventures LLC.
Okay, did you say Berg?
Burke, B-U-R-K.
Oh, Burke, okay. Thank you. And Mr. Sommerfeld, are you still, you're representing defendant?
Yes, Your Honor.
Okay, thank you. This matter is before the court on the plaintiff's motion to set aside stipulated order of dismissal, enter a consent judgment, and set the matter for hearing in this matter. Go ahead, Mr. Burke.
Thank you, Your Honor. As the court's already aware, plaintiff HHB Joint Venture.
Tyler, we have to talk. We have to talk, Tyler. What happened to your hair? Who did that to you? Ostensibly, you paid money. Or did you do that to yourself? I mean, would you just shave it off? You're allowed to have a shaved head as a lawyer, right? You can just shave it. Would you not shave that? Oh, it is a pair of interlocked cock and balls. Oh my God. This is so nuts. This is like. Do you think that it stays up like that naturally? Do you think he put it up like that? I have a feeling it stays up like that naturally. But it could be a Vanilla Ice thing.
venture seeking to enter the consent judgment against the 5 at issue defendants in the amount of $1,194,000. We have not received any kind of response.
$1 million? Did he just say that? Hold on. Did he just say it? Did he just say that? $1 million.
For the court on the plaintiff's motion to set aside stipulated order of dismissal, enter a consent judgment, and set the matter for hearing in this matter. Go ahead, Mr. Burke.
Thank you, Your Honor. As the court's already aware, plaintiff HHB joint venture seeking to enter the consent judgment against the 5 at issue defendants in the amount of $1,194,000. We have not received any kind of response in opposition to the request to enter the consent judgment or the motion to set aside the dismissal. We predominantly rest on our motion and brief in support. This matter is akin to a conditional dismissal pursuant to Michigan Court Rule 2.602C. And it's outlined in our brief in support. The court has the ability to grant relief from the dismissal. The court has reserved that ability in the dismissal already. We request entry of the consent judgment in the amount set forth in the affidavit in support.
Okay, thank you. Mr. Sommerfeld, what's your response?
My client has not comply with the settlement agreement, so the relief requested is appropriate. We did sign the consent judgment as part of the settlement.
Okay, thank you.
Sorry, Your Honor.
Okay. Court notes that the defendant had agreed to the initial amount of the award in this matter being $1,650,000. They had also agreed to enter a consent judgment in the event of default, and that again, apparently is what's happened, and there's no opposition at this point. The court will grant the order to set aside the dismissal, enter a consent judgment in this matter, and that will be the order of the court. Anything else, Mr. Burke?
Just on attorney fees, Your Honor, we are ready to proceed with testimony if Your Honor is ready for that. Or
I don't take testimony on Mondays. We have motions and we have probably about 25 motions, so I have no time for testimony.
Would you like us to notice the date out?
Contact our office and we'll set you up for a Wednesday afternoon, and then we can take testimony at that time.
Thank you.
Okay.
Your Honor.
Thank you. Gentlemen, you're free to go. Have a good day.
Your Honor.
Yes.
I have a motion to withdraw as counsel from the defendants up.
Okay. Sorry, I didn't, they didn't process and send that to me, so.
Oh, I'm sorry. I don't.
We're just checking that,
Yeah, we don't take testimony on Mondays. We
the
don't take
Sommerfeld, because we don't have that. We're not able to find it, so it may have been filed with the clerks and they never processed and sent it to us. Why don't we do that? It's when we get with you and get a Wednesday, why don't you reschedule that or renotice it for that Wednesday? And I know it's a problem because then you have to stay in longer, but
right.
We just don't have the motion, is all.
Okay.
Yeah, we don't show anything that's in the file at this point. So if the clerk's got it, they have not again processed it, and they have not docketed it yet.
You guys, could he have like a brain injury and have needed it shaved, and we would just be really bad people? Because I'm like thinking, should I call my sister who's a hairdresser and ask her what the fuck happened here? Like, how did this get done? And then I'm looking at his head and I'm like, is that a bit of a divot? Does he have a divot in his head? Like they took out some of his skull, allegedly?
I don't know why. You'll have to call them and find out.
Okay, Your Honor.
And then just set it for the Wednesday. We can take care of that before we get into the hearing on the attorney fees.
Okay, Your Honor. Thank you.
Thank you.
Thank you.
Free to go.
Actually, it costs $1 million. Not free. That's just a bad haircut. But he won the case, you guys. He just won $1 million. You know what he's doing right now in his office?
Which one we gonna go to
Fuck
next?
yeah.
Oh,
Fuck yeah.
attorney
Fuck yeah.
Sachs, it's
That's what I'd be
going to
doing.
Young v. Young.
Oh.
It's actually attorney Hassan.
Elizabeth, you're so close, but I can still see the light
Okay,
peeking
we
in.
have legal aid then.
Yes. And that, it's Elizabeth.
Oh, that's right. You threw me off. You changed your name and I was looking for a different attorney. I'm sorry.
No worries, Judge.
I see you all as names, and I don't ever see you as real people.
Please.
Megan Elizabeth Shoemate.
Who's that? Megan who?
Okay, Megan, I am going to place you in the waiting room. I will bring you in when we're ready to call your case, okay?
Okay, thank you.
We
Okay.
do not have any parties present from the Young v. Young case. Calling case 2024-537 DM Kelly Young versus Antonio Young. Today is Monday, July 29th, 2024 at 9:46 a.m.
Court will note the attorney, Ms. Basson, on behalf of the plaintiff in this matter. This matter is before the court on the plaintiff's motion for support investigation in order for genetic testing. We had previously on the hearing on June 26, 2024, determined that genetic testing was appropriate. So the court is going to sign that order and get it entered today so that you can proceed with the genetic testing. You would also ask for a support investigation. I think that Ms. Basson, could we simply take care of that at the hearing when we have a hearing in this particular matter? I don't want to overburden the front of the court with investigations when there may not be any dispute on that.
Judge, the defendant has been defaulted in this matter, and we're unable to even locate him at this point. I've contacted him directly. He indicates that he's living in California. However, his social media indicates he's living in Texas potentially. We've been able to get even no address for him. So at this point, we're just kind of in a situation, Judge, where we don't know where he is, what he's doing in terms of income. You know, we are seeing again from social media, he's getting these large payments that he's indicating, but we have no idea what he's making, how much of that is on the table or under the table.
Let me ask them, how would a support investigation assist? Wouldn't the front of the court have the same problems? They can't locate him. They don't have any information either.
Judge, they have resources that private attorneys simply do not, due to the nature of what an FOC office is. So they can do things like see if any W-2s have been filed in any state for this individual. They can do more investigation work than we are able to do just based on what's publicly available on his social media. You know, I can impute income if Your Honor has an amount that you believe is acceptable for me to impute.
Well, what we'll do is, I don't know that it helps. What we'll do is typically in these matters, the court looks at what's normal in the Carroll County area. You can impute $15 per hour full time. That will probably get us to the point where probably reasonable anyway. So you can do that, and we'll get. In fact, I have signed the order for genetic testing, so that will that'll get sent out to you here shortly. So you can do the imputation and get that in as well, and do it under 7 days.
Will do, Your Honor. Thank you.
Okay, thank you. Have a good.
Oh, that's, if she thinks he's making that good money, she didn't fight very hard for that. Couldn't she just, Now, if he successfully avoids going for this genetic testing, they can't really start the order. Can they impute in the meantime?
Yeah.
Thank you.
Now she's crying after her hearing. We had him dancing. Now she's crying. Also, don't worry, I have a few more after this. Just a few. Just a few. This is the beginning of the week, and it's July.
Please unmute.
There's, oh, look, they have red chairs. Red chairs. Red chairs and wood paneling.
Calling case 2024-1612DS, Shawak Kuykendall versus Aaron Gorman. Today is Monday, July 29th, 2024 at 9:50 a.m.
Court will note the appearance of Mr. Murphy on behalf of the defendant. This matter is before the court on the defendant's motion to establish custody and parenting time. I take from what you have, Mr. Murphy, you stated that the parties had been alternating weeks in this particular case, and I guess that is all the information we have at this point. Is that accurate?
Correct, Your Honor. And at this point, the goal is to get something established as far as a custody order goes, so that moving forward, they will always have an order in place.
Okay. Well, the court will continue the status quo. Court will note that the plaintiff has not appeared in this particular matter, so the court will grant the parties a temporary basis, the temporary joint legal and joint physical custody. Support will be pursuant to guidelines in the child support formula, and we will handle the parenting time on alternating weeks from 6:00 p.m. Friday through 6:00 p.m. the following Friday, and the court will order parenting time and alternating holidays as well.
And Your Honor, if I may note, one of the things that they are asking for is asking to expand the parenting time for my client. As of right now, we understand that barring a hearing or a FIG or something of that nature, we can't make those determinations. The purpose of this motion is, rather than file a complaint to establish the custody outside of an active case, filing it in this case to make sure everything's handled all at once. So for a temporary basis, we understand that things will remain the same. I just want to make sure it's clear that they are asking for an additional parenting time as we move forward.
Well, and we can address that at the time that we have a hearing in the matter. I'm not going to, again, obviously we're not having a hearing now, and so we'll have to address that at a later time.
Understood, Your Honor.
You can submit that order under a 7-day notice of entry.
7-day notice.
Thank you.
Entry. Confusing for the pro se peeps, but we know that means file it within 7 days. You don't have to motion it because they can sort of keep on to it. What that tells me is that the clerks keep their work on the desk for 7 days. Anyways, let's do a few more. Shall we? We shall. Yay! Ma'am, your forehead. And this is somebody, I have a large forehead too. I realize that.
I'm sorry, it's right. Pause right here. For the record, this matter is before the court for a continued pretrial conference subsequent to scheduled mediation with Mr. Walker for the front of the court. Present this afternoon via Zoom is Attorney John Danielski, representing the plaintiff, Marlise Guchow. Ms. Guchow appears to be present. Good afternoon, Mr. Danielski.
Good afternoon.
Is Albert Epps present in audio? It appears that he is not. Mr. Epps has not contacted the court. Have you or your client had any recent contact with Mr. Epps?
I just emailed him and I called him. I know with the adoption paperwork went to his house about 5 or 6 times. He never answered the door, but I did email to him and he was in court last week with Judge Lohmeyer.
Dodging adoption paperwork is terrible. What? Make it make sense. Make this make sense. If you haven't guessed, I haven't watched this yet, so I have no fucking clue what's happening.
So you got no response then this afternoon from Mr. Epps?
No, Your Honor.
Okay.
How many visible crosses
Record
does she
reflected,
have?
Mr. Epps failed to appear for the scheduled mediation, which was scheduled back on June 7th, 2024. Also failed to appear for the continued pretrial conference subsequent to that mediation. Also before the court is a motion filed by Attorney John Dalsky on behalf of the plaintiff mother, motion to transfer case to Judge Lohmeyer for the reason that apparently Ms. Guchow has petitioned for a step-parent adoption in that court. Is that correct?
Yes, Your Honor.
Mr. Epps appeared before Judge Lohmeyer recently.
He was there last week, Your Honor. And the judge set it for a trial on August 19th. She's got an evidentiary hearing.
And what was Mr. Epps stated that he was opposed to any adoption at that time?
He didn't consent at that time.
Did
She
he
set the
state his
trial.
Did he state a position at all?
My client and my secretary would have to speak to that. I had a hearing at the same time in Oakland County.
Your secretary? You can't. What? You can't send your secretary? You're a lawyer. That's like when I was an engineer, administrative assistant or executive assistant. They can't send me in their stead. I don't know what the right shit is to know. I mean, the only thing that I would say is fine is if you said, my secretary recorded the court hearing and I'm going to review it.
And Judge Lohmeyer kindly let me cover that hearing first. I believe what was stated, my client can confirm this, is he objected to it, but I don't think he said anything more. I think that was the extent of what he said. I could ask my client, Your Honor. She was there.
So you did not appear at that hearing. It was just simply the parties?
It was just yes, because we were supposed to start a trial that day and I was delayed. And Your Honor knows what's going on with my office with Mr. Berger leaving. And so I was going to start the trial late. Mr. Epps did appear and then indicated he objected. My understanding is, and so she set it for a trial on the 19th.
The only thing is they tend to say paralegal when they are paralegals. And what's the Berger situation, John?
Or this court surprised she scheduled a trial day without any input from you in terms of when you were available?
My secretary was present via Zoom. I did tell I was able to speak briefly before the hearing and indicate that my secretary can log in and she will have my schedule. So my secretary was present and told the court when I would be available.
Very well. Did you mail this motion transfer case to Lohmeyer to Mr. Epps?
I emailed it that same day it was filed to Mr. Epps, and Judge Lohmeyer sent an email. She confirmed Mr. Epps' email. She sent out a notice for the evidentiary hearing. She emailed it to Mr. Epps, me, my client, and in response to that email, I came back to the office and I drafted this motion the same day. I believe it was that same day. Whatever date is on the motion, but I think it was that same day, and I emailed it to Mr. Epps along with the exhibit.
Thank you, and I do see your proof of service by email. Does Judge Lohmeyer need this file in order to proceed with the adoption?
She didn't specifically state that, Your Honor. She indicated that she was interested in merging the two cases. There's a case that came down in January of this year where there was a temporary custody order. I was not aware of that case until after the last hearing. When I filed the adoption case, I gave Autumn Barnett that case because Ms. Barnett had said, well, we don't have a final custody order. I said, well, there was a case that came down in January by the Michigan Supreme Court, not the Court of Appeals, I believe it was, that said a temporary custody order is good enough. And I emailed that case to Ms. Barnett when I filed the adoption paperwork, and they accepted my adoption paperwork. So I don't know. The case law says I don't need a final order, but I think Judge Lowemeyer was interested in merging the two cases to,
But with objection, I don't think, what is the case that you're citing saying that they proceeded with adoption on temporary orders as sole decision maker for the child over objection from the other parent? This sounds odd to me. I would be shooketh if a court would do this. I don't know what the need would even be. I'm not sure that a child adopted gets more rights than a stepchild if the parents are married. Perhaps like insurance that carries on after, I don't even know. I think that might still go to a stepchild if they're on the plan. I'm really trying to figure out what the plus side would be here.
make sure everything is in order. So.
Very well. For the record, it's now at 2:10 p.m. Mr. Upsfeld to appear for the 1:30 mediation. Something be noted on the record, Mr. Danielski, and the court will grant your motion to transfer this case to Judge Omeyer.
Okay, thank you, Your Honor. I'll prepare an order. All right, thank you.
All right, that will conclude this matter. Good luck, ma'am.
All right.
Thank you.
I guess, but is he gone though? I'll have to try and find out how to see Judge Omeyer's court on my other list of things to do. I have a huge list. I wish it was as good as a huge kiss. Oh, that's the end of it. I was like waiting for it to play again. I have another one. Oh dear. Oh dear.
From the front of the court this morning.
Oh my God, sir.
It was scheduled for mediation 8:30. It's now 9 a.m. The present is Attorney Alex Goldman, representing the plaintiff Kendra Malice. Ms. Malice is present. Sir, are you Justin Malice?
Yes, Your Honor.
Mr. Malice and Mr. Goldman, have the parties reached their own agreement this morning?
Only to attend another mediation. Mr. Malice recently acquired counsel who was unable to be here this morning, so we are going to mediate again with the assistance of his attorney.
We have a one-year marriage. Mr. Malice, there's no attorney appearance. This court will not adjourn this matter. I'm ordering you to engage. This has been scheduled for some time.
What? Judge! Did he just say, I will not adjourn this matter? I'm ordering you to go ahead without your attorney? Judge, look at her face. Look at her face, too. Oh, shit. All contentious. That is fucking tragic. Oh, Jesus Christ. Only a year. What are they fighting over? No children. No alimony. Are they just fighting over the sex toys or something? What?
The court mailed out this notice on May 31st. We're not going to play games, Mr. Malice. The court has not received the courtesy of a phone call from an attorney. There's no appearance. Mr. Goldman, have you received the notice from an attorney?
No, Your Honor.
Okay, this has been scheduled. These are valuable time slots, Mr. Malice. We just can't play games here. So I'm going to order you to continue mediation. Get to your attorney on the phone. I mean, he should be here. It's a one-year marriage. There's no real estate. You've got a fee waiver. Did Mr. Malice pay the fee waiver of the $255? Mr. Malice,
Your Honor, I have since lost my job. Since the last time we were here in court.
I'm asking you whether you paid it or not.
No, Your Honor, I have not.
Okay, so that needs to be addressed in the judgment. And there's personal property, custody and parenting time. So the party been separated since January. What items of personal property are in dispute? So I'm gonna, Mr. Walker, good morning. I'm gonna have you meet with the parties Mr. Malice, if you want an attorney, you call him right now, tell me he needs to zoom in. We're gonna mediate this matter this morning.
Okay, give me a moment, please.
There are, well, I want you, I'm not gonna waste Mr. Walker's time. Mr. Schedule 8:30. Mr. Walker has a very busy schedule today. Did Mr. Malice zoom out?
He went to call his attorney.
Okay.
He hung up to call his attorney,
All
Judge.
right.
Like you ordered
We
him.
just, I don't know if he calls attorney, but I mean, this is a pretty simple matter, isn't it, Mr. Goldman?
Your Honor, I think the custody and parenting time issues are going to be contentious.
Okay. What's been the practice over the last,
Is this ex parte
Seven
right
months.
now?
The children have been in Miss Malice's exclusive.
I'm being serious now. Is this not ex parte? And the judge should know better.
Care, and Mr. Malice has not attempted to see them.
well, that's right there. That gives you a pretty good idea. If he's not filed a petition for parenting time.
I agree, Your Honor. I was, I'll look forward to hearing what his attorney has to say.
All right. Mr. Mouse, were you able to reach your attorney?
No, my attorney is on bed rest. He just got out of surgery for a heart valve. So I don't think I'm going to be able to get him on the phone right now.
All right. Again, all right, I'm having a talk with Mr. Walker. It sounds like personal property is not really an issue. Mr. Malice, where'd you go? Well, what items of personal property are in dispute? I mean, it sounds like from Mr. Goldman, it's primarily custody parenting time. The court has been informed you've not made any effort to petition the court for parenting time. So it appears pretty clear in terms of what the court's gonna look at in terms of custody parenting time, what's happened in the last 7 months, what's happened since you separated. So with that, talk with Mr. Walker. Let's see if we put the proofs on the record today, and let's move forward. And then you can also give the court a date when we come back in terms of when you can pay that $255 filing fee. Ms. Malice is still on public assistance. Is that correct, Mr. Goldman?
Yes, Your Honor.
All right, we're gonna have you go back into a meet with Mr. Walker again. Mr. Walker, if you don't mind, talk with the parties a little bit further this morning. I'll be available all morning.
Thank you, Your Honor.
He's
All
a
right, thank you.
mediator. I wish I had caught
Sarah.
the end of that or the
Will you
result.
please put the parties in separate rooms? We're going to mediate in separate rooms.
Okay. But I didn't, unfortunately. I am getting better though, you guys. I do want to say, because now I have 2 computers. I can do more work.
Things going as planned today.
But it's just getting used to that fact. This was just weird. That was just a really weird little hearing. All right, one more. Time for one more. Hi, Navar. I'm not jumping around today because I got the best little mini computer around. And it's green. It's so cute. It's smaller than a boot. And it works. It works. And the guy said nothing. It was crazy. I know. It is amazeballs. All right. I can't believe I don't creed frame when I pull it up. I got other shit running. I'm not creed framing. Life is a highway. I want to ride it all night long. I'm not going to ride the computer, though. I don't think it would support me. Oh, Crystal with the H. C.
Phone disconnected.
Pardon?
37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2023-858 DM Kevin West versus Crystal West. Today is Monday, July 29th, 2024 at 10:28 a.m.
Court will note this matter is before the court on the plaintiff's objection to referee order. Mr. West, I noticed I reviewed your objection. Some of the issues were I guess I say obviously discrepancies, but minimal. I mean, as far as one that the referee had misidentified a witness as, it was an Eric, he identified him as Gary. He stated that you lived in an apartment. You're saying, no, you lived in a house. Also, he said you changed your job 3 times and you said you've only changed once. Again, those are not anything that the courts are concerned about. Address your objection, sir.
The main reason for the objections was just to make sure that the record was straight. It felt like there was quite a few errors and contradictions in the referee's findings. As I laid out a few of them there.
Okay. Well, your job in these to set it aside. What happens? The court has to. The referee had to make a factual or legal error in this matter, and I guess a factual or legal that would go to the substance of the proceeding and not some of these, small discrepancies.
Well, my biggest concern is the missing testimony from myself and my witnesses. There was nothing in the referee's report about how the children have been staying with me outside of the current order for the last 3 months that they were in school.
Okay.
And there was nothing in the contradictions in the report between his claim for me to not have a custodial relationship with the children, but also saying that I have the emotional and physical connection with the kids in other portions of his findings. It just seems to me like he picked and chose certain things in the testimony to fit the narrative that he wrote out.
Well, what happens is obviously in these instances, the referee has to consider a lot of different factors. And again, sometimes, like you say, well, you didn't mention, well, you don't mention all of the evidence. And I always state when I have these hearings, I might go through 3 days of testimony. I can't spend 3 days going over and reiterating all of the testimony. So what you'll do is you will reiterate the testimony that is relevant to a particular point or that you believe is relevant. And again, I can't see that the referee didn't do that based upon what the referee's whole finding was in this particular matter. So I guess I'll ask Ms. West, do you have anything to add in this matter?
No, I don't.
Okay.
Thank you, sir.
Anything else, Mr. West?
I guess I just don't understand the how the agreement that Crystal and I had outside of the current order, how that's not relevant to this case.
Well, you can have agreements and that's fine. And if you do have an agreement, you want to, again, put that agreement in place, you can always do a stipulated order, which would in fact set forth whatever that stipulation is, and the court will enter it. So if you have a stipulation at some point, you can do that. What happens though is the referee is not bound by the stipulation. If in fact there is evidence taken, the referee is bound by the evidence and not the stipulation. So what you say is I looked at what the referee had ruled at in this particular matter, and referee made a factual determination after hearing all of the testimony and evidence, and based upon that, the court cannot find that the referee made a factual or legal error. Again, you're free to agree to anything that you want to, but I can't see that the referee made a factual or legal error. So the court is going to deny the objection at this particular time. And if the two of you still have some sort of an agreement, you can prepare that and put it into an order. If you both sign that, send it to the court, and we can get it entered. So that will be the order at this time. You're free to go. Have a good day.
Thank you.
He looks flabbergasted. Is he frozen? Nope. He was flabbergasted.
An objection. Why don't you do the order to set aside? Okay, and then I could just Because
Get
it's
back to
kind of,
work.
even though it's an objection, it's kind of what it is.
Right, yes, I did prepare order after motion sunset.
Do you think that he
Yeah.
does these on Mondays? Oh, what the fuck does that say? WingTech Celero 5G Plus. What do you think the judge has for dinner on Monday nights? Do you think that he has like a makeup for this shitty day dinner? Or do you think he has like a nice Sunday dinner in preparation for this shitty day? You know what I mean? Or is it just me that rewards myself with food? Sometimes I say things out loud and realize, oh, that's your problem, Paisley. I would you think 3 martinis? Oh, I don't know. He strikes me as like a really strict, like routine guy, and that things must be the same. Yeah, tea, crumpets, and Sudoku. That sounds like it, right? Or maybe like pate and oh, don't we all wish we don't? There are country clubs here, sort of, but not the same as in the States, at least not where I live in Victoria. And but there are like prestigious golf clubs, but they're really for golfing. Like they're not the type of places that you would go and hang out, even like to be like it's just not the nicest restaurants, not the nicest place. They're for golfing. For example, a lot of car dealerships hold their Christmas parties at like golf clubhouses or whatever. I remember going to a few. Now I just thought about it. Oh, you think he gets a drive-in? Oh, that would be interesting. And Hector, yes, your channel is fantastic. Are you back up and running, Hector? Has YouTube Daddy talked to you again? Such a fickle master, we know. Just a year ago, he slashed my dreams of the first channel. But we're going strong this time, aren't we? Yeah, that's right, babe. Yeah. And I like to point out I got 2 channels monetized in a year. That's actually pretty good. You can't upload. That's fucked. I don't understand.
I believe this is Antonio Nelson. Good morning. Your first and last name, please.
Good morning, Antonio Dupree Nelson.
All right. You will need to speak up.
Do we have a
Antonio Dupree Nelson.
for Hector? We should get a command for Hector. It should be something like, it should be like exclamation mark trip. And then it should say something like, love watching drunk people fall. Check out Hector cam clips. Let's remember this and have Jonathan or Sashina do it.
We got that, sir, but when I give you some time to speak, you're gonna have to speak up because it's real faint.
Okay, yeah, I'm on a lunch break. I'm in a non-service area.
Okay.
Calling case 2010-1553 DP Christine Zinke versus Antonio Nelson. Today is Monday, July 29th, 2024 at 10:34 a.m.
This matter is before the court on the plaintiff's motion to set aside referee determination. The court did review the motion in this matter as well as reviewing the file, and the plaintiff did not appear. But I will tell you, Mr. Nelson, so you're aware, we checked the file and the referee's motion obviously was sent out to you. There was no proof of service of that motion on the plaintiff. So based upon that, it does appear that she was not notified of that particular hearing.
Excuse me, sir. I put the mail in the blue US mailbox. I put the letter in there.
Okay, well, there was no proof of service, and obviously the court goes upon that. If there's no proof of service, then the court can only go with based upon what the evidence shows, and the evidence shows that she wasn't served because there was no proof of service.
I don't understand how she wants to serve, and I put it in the mailbox, Your Honor.
But if you look at the court rule, when you
You have
file,
to file paperwork for that, sir, and you're not allowed to yourself deliver it. It has to be another adult not related to you or the case, or you can hire somebody to do service because it's actually a little bit of a persnickety little thing. There's all these little rules and regulations about it, and you have to have proof. You have to have proof to the point where somebody files it with the court or they're willing to come and testify that they handed it to the person, that they delivered it, etc., etc., etc. Sometimes people complain about the cost of service to like hire somebody, but there's a reason that lawyers do it like that more often than not. And it's not just about like being able to just call somebody about it. It's that it's very important. Service is critical. The judge has been denying shit left, right, and center, but this one he's going to grant.
something, you have to do a proof of service to confirm that there was service. There's no confirmation of service in this matter. And she has stated in her motion that she was not served and did not receive that. So I can only go with based upon what the paperwork shows.
Your Honor, I didn't get no mail. I knew because I'm in street court with Judge Richardson. That's the only reason I knew I had a court date. I would have never knew if I with the mail. I didn't get no mail, sir. I learned because I'm in street court because I have my license down.
Street court? What the fuck is street court? Immediately need to look it up. Hold on. In front of which judge did he say? Nothing's coming up when I look up street court, but I'm assuming, is it drug court?
I've been doing everything I was supposed to do. I've been working
Well,
what I've been doing right. And I called.
This is what happens is the court is going to refer the matter back to a referee for a full hearing on child support because that didn't happen because based upon the file, the plaintiff was not served. So what happens, you'll get notice from the referee as to a new hearing. Is there anything else, Ms. Zinke?
No, that's fine.
Okay, Mr. Nelson.
Oh my God, I thought he called her Miss Stinky. And I was like, Judge, you are being savage today. It's Zinky with a Z. Oh my God. Zinky. We got to find this street court. We got to find this street court. Cynthia's out here dropping knowledge for us. I like it already too. The street court is here. This is street court. Stinky. It's Zinky with a Z.
Anything else?
Yeah. My thing was I'm the head of my household, and I have to pay so much I could never pay my rent and bills.
Okay, well, what happens, all this does is refers it back so that she has an opportunity to, again, testify, and then the referee will make a determination. He may make the same determination. I have no idea what he's going to do, but at least this gives her the opportunity to be present and testify. So that will be the order of the court. You're free to go. Have a good day, and you'll get notice here shortly from the referee.
Thank you.
Look at him smiling. Did you see that?
Christine Barbara, Amber Wilson, and it's 10:37. So you wanna go on the record or no?
West, what do they do on the west?
West, we already did them.
Yep, it's here. Oh,
Remember
I denied
West?
that on West.
Now do a referral order. Would you like me to bring attorney or no on the debtor's exam?
You can bring her in.
Would you like me to call the case?
When we bring her in.
Judge just zooms back down. Just back down. What is this? Are you gonna bring them in or not? Cynthia. I love it. Sometimes I wonder what he Googles.
He's what?
She's not.
What you Google. I wonder what you Google. You know, when you're just in private. What kind of shit do you want to know?
She's not on.
Start video and she's not responding. Here she is.
She looks like a cartoon character.
Calling case
Despicable Me.
2022-3307 CB Dawn Food Products Incorporated versus Rock and Roll Donuts LLC et al. Today is Monday, July 29, 2024 at 10:39 a.m.
Court will note the appearance of Ms. Mueller-Wilson in this matter. This matter is before the court for a debtor's exam. As it relates to the defendant in this case, it is now 10:39. The matter was set for 10:30. The defendant has not appeared in this matter, so Ms. Mueller-Wilson, the court will grant and award to you a bench warrant in this particular case. You wish to speak to the issue of bond?
Yes, Your Honor. The judgment amount is $33,677.84. Needless to say, that's an extremely high amount.
Wait, did she say 600,000? Hold on, I gotta go back.
The judgment amount is $33,677.84. Needless to say, that's an extremely high amount. So I would suggest a 10% bond, approximately of $3,000.
Okay, the court has no problem with that. The court will grant a 10% bond. You can include that in the bench warrant and the bond amount, and you can submit that under a 7-day.
Thank you, Your Honor.
Okay, thank you. Have a good day.
You as well. Thank you.
That 7-day loophole. Okay, I think we have one more. Just because I want to see what else happened in his day. Yes, Judge. Also, I can't remember. Well, I don't know. I can't.
Custody.
Oh my God, a terrible beard. I only caught a tiny sight of it and it's fucking disgusting. Take heed, please, people. Make haste to the bathroom and shave, sir. Oh my God.
Please unmute both of you. Mr. Katie.
Yeah. Is his name Andrew? What's his name?
Yeah. One moment, please, to get the record open. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Monday, July 29, 2024 at 1:22 p.m. And this is case number 2024-1357 DC, Andrew Katie versus Ella Grapp, Attorney Redmond for the defendant.
Good afternoon to both of you.
Bye, Bev.
Mr. Katie, I'm going to start with you because you are the plaintiff, and then I'll get input from Ms. Redmond in this case. This is a scheduling conference, and that's where the court attempts to put in place various dates and processes so that the case would proceed in an orderly fashion. So
orderly fashion is not the first thing that comes to mind when I was right. His name is Andrew. Oh, weird. Remember, I have nothing in my brain. No pictures, no words. Like, I don't see anything. But sometimes things, like, did I read it quickly when I saw him? Did I fucking remember it from before? I don't remember. I don't know. What the fuck, though? This just looks like an overgrowth up here that he's, like, twisted down here. I know you meant beard, and I'm laughing.
In that regard, sir, I need to know what issues do you believe to be in dispute in the case? Is there custody, support, parenting time in dispute?
Hi. Yeah, there's custody. I guess the child support is also
okay.
an issue.
Please stop touching it. Ew. Please stop touching it. I feel like we were all just subjected. Ugh. 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 Brother. Ugh. Brother. Ugh. How does that meme go? Like, oh God. It's just as bad. It's bad on your face, but you can't touch it all creepy like that in the middle of you talking. That really creeped me out. Well, I'd shave him while he slept. If he refused to do it himself, I'd do it while he slept. Or I'd tie him up. Ooh, brother. Ooh. What's that, brother?
I guess the child support is also
okay.
an issue.
I'll put down parenting time as well. That would encompass anything in the
Right.
DC that you might have. I don't assume that doesn't leave much for you, Miss Richmond.
It's red.
I did want to. I mean, I'm not sure what this hearing is exactly about, and I wanted to say.
Okay, if you would listen, hold on. When I started, I said it's a scheduling conference. We put in place various dates and processes so that the case will proceed in an orderly fashion. That's what it's about.
Right. Well, what I don't know specifically is if I was planning well, first of all, I was planning to negotiate with Ms. Grapp this next week and hopefully settle the case without obtaining representation. And I was concerned that if I don't have representation right now, that the scheduling wouldn't. I would have to know the lawyer's schedule. Because I am planning to hire representation if I can't settle the case very quickly.
Okay. Well, by putting into place the dates, what I'm doing is putting in place at the outside so that, for instance, the next question was going to be, are you in need of discovery? And then we could put a discovery cutoff date in place. So, sir, discovery is the process whereby you acquire information from the other side that you need. And are you anticipating that you'll need discovery?
Yes.
Okay. Ms. Redmond, are you anticipating discovery?
Yes, Your Honor.
Okay. We are relatively early on. What I will do is it's not that early. I will give you until, because if Mr. Katie is going to potentially get an attorney, I'll give you until October 1 as the discovery cutoff date.
October.
That means, sir, what happens is you have until that date to get information from the other side. Okay?
Okay.
And your attorney will know what that is.
Do you hear how long it took him to say that? Oh, he is out of his depth right now. I think it might be a clip on. Fuck off my lawn, Streamlabs. I think it is a clip-on tie.
Gives him sufficient opportunity to, if you're not able to come to a resolution. I will tell you, because it's out, you are at 84 days currently, and it is October 1, I will not extend that date. So if you can't get an agreement here relatively soon, you need to get right to an attorney, because he's going to need to make sure that he has sufficient time for discovery. Okay, the court would then set mediation as in October. Don't assume, sir, you have any mediators that you recommend?
Not at the time.
Okay.
I was talking to a lawyer who did have some recommendations.
That doesn't help us today.
Yeah, nothing today. Yeah.
Okay. Ms. Redmond, who do you recommend as mediators?
I would request John Brundage. I know he gets very booked out, but if it's in October, hopefully he'll have something open by then.
I think he would. I know he's booked up in August at this point.
Okay.
And who as an alternate if he's not able to serve?
Kelly Podolsky.
Sir, do you have any problem with Ms. Podolsky serving as an alternate, Mr. Brundage as the mediator?
Well, I don't know.
No.
Is there another chance to go over that?
Nope, this is it. This is what we set in place. I will tell you, Mr. Brundage does about 90% of all the mediations in the county, so he's very acquainted with mediation and the courts.
Is he rolling in it? How many are that? Is that?
Well, I mean, I don't necessarily want to agree to someone I don't know anything about more than that. But I'm not sure what the alternative is.
Well, there is no alternative other than the court would send it to the mediation clerk and they would randomly assign it, and then you may or may not get someone that either party wants or recommends or anything of that nature.
Right.
Right.
I will put down Mr. Brundage and Ms. Podolsky. If you do get another attorney, they'll get an attorney, then they can always file appropriate action if they want to try to change the mediator.
Oh, okay. All right.
The court will schedule November 4th at 1:30 as the settlement conference date. Parties are required to be present unless they've come to a full agreement prior to that time. With that, Mr. Cady, is there anything else or any questions you have?
No.
Okay. Ms. Redmond?
No, thank you, Your Honor.
Okay. Thank you both. You'll be getting this order. I'll tell you, sir, in the event that you can't get an agreement, you don't have an attorney yet, there are dates that appear in these orders. Make sure that you comply with those, because it could have consequence in your case if you don't file a witness list or exhibit list or something of that nature. So just make sure you pertain or that you comply with all of those dates.
Okay.
Okay. Thank you. You're free to go. Have a good afternoon.
Thank you. You too.
Thank you.
What else you got, Judge? A little bit left, or is it Wordle time? Tell me. Also,
Both of you.
what the
Good morning, Your Honor, or good afternoon.
Good morning.
Again.
Okay, this is now case number 2024-555 DM. Matthew Meisner versus Linda Meisner. It is Monday, July 29th, 2024 at 1:30 p.m.
Okay.
Attorney Core for the plaintiff. I do not have defendant or counsel Attorney Podolsky.
Ms. Greenlee-Clore, enlighten me what's happening in the case and why don't I have Ms. Podolsky present?
I don't know actually, because I spoke with her earlier today and she was anticipating on appearing today. But she did send me over another proposal. So I think what we're going to be doing is just drafting a final judgment. But I did anticipate that Kelly was going to be signing on here, so I'm surprised that she's not. Maybe she's expecting a call instead of logging in.
Well,
No,
we don't call people on these.
I don't know.
Yeah.
I'm just speculating.
Well, I will leave it at that. You believe that you may have some resolution.
Objection, speculation.
And maybe that's why.
Deal with it.
And what we'll do is, I'm sure we have a settlement conference date on this.
I don't know that we do, Your
No,
Honor.
we don't
because-
actually.
Oh,
Yeah, this was a pro se that I came onto just to draft the final judgment, and then we've been working through that.
okay. Well, what we'll do is set a settlement conference date in about 30 days and have you back at that point. And if it's not resolved, then we'll set a trial date.
Okay, that sounds good.
Okay. Thank you.
All right,
Before
thank
go,
you.
have a good day.
Thanks. Bye.
Podolsky just appeared right now.
I saw it.
You want
Courtney,
me
we
to
got,
bring
like,
her in?
Yeah, bring her in.
Okay, we'll tell her what happened. But yeah, what happened in this case is that the parties did not have attorneys initially, and when we had the scheduling.
Oh, there's
conference,
Ms.
they-
Ms. Podolsky, good afternoon.
Hi, sorry about that. I'm so used to you guys calling. I forgot this was Zoom.
Okay.
When do they ever call Miss Podolsky? They don't. We just said that. They're my deal with it glasses, Hector, like the llama meme, the drama llama mama meme mama. Mark.
Well, what Ms. Greenlee-Clore was here, she kind of enlightened us that you've been sending proposals back and forth. We told her that we would set up for a settlement conference about 30 days.
Okay.
And at that point, if you guys haven't resolved it, we'll set it for trial.
Okay, absolutely. That's fine. Yeah, it's just some minor changes.
Okay. Okay.
Okay, thank you.
We'll let you
Apologize.
go. Have a
Thank
good day.
you. Bye, you too.
All right, and now let's go on to the last one here.
Thug Life glasses? Is that what they are? They were on my Amazon wish list. I have really cool shit on there if you want to check it out. I know somebody can hit exclamation mark link.
Can you hear us, Mr. Mansour?
Oh, Mansour.
Hello?
Yes, Your Honor.
Okay.
Yes, Your Honor. Can you hear me well?
Yes, we can hear you.
All right, so this is case number 2024-1760 CB. Mindset Alchemy versus EPS 1. It is Monday, July 29th.
Alchemy sounds like a fucking weed strain that is delicious, doesn't it? Mindset Alchemy. It's a hybrid with fruity notes and a really great, I don't even know how to sell weed anymore. It's not hard to sell weed, I'll say that. You know, selling cars, way more difficult than selling weed. I sold a lot of weed. Allegedly.
2024 at 1:33 p.m. Attorney Sean Mansour for the plaintiff, no attorney for the defendants.
This matter is before the court for a status conference. Mr. Mansour, enlighten me what's happening in the case.
Your Honor, I've spoken with defense counsel. I don't know why a status conference was issued in this case. Defense has failed to file an answer. They're within their time frame. We've yet to file a default in this matter. He just contacted me today, and he let me know that he's at an appointment with his mother, a doctor's appointment. I think he contacted the court as well. I relayed the message, or I reiterated that I would let the court know that he was.
He did contact and talk to staff about that. I remember hearing the phone call.
And Your Honor, I have no problem with giving him the time needed to file an answer.
Yay, Jude. Hey, Jude. Don't get me banned. Awesome. Allegedly. Are fat ties in again? I don't keep on track with ties at all. Vince would tell us, maybe. I don't know. Vince lives in the big city. We always get everything late.
Answer at this time and adjourning the status conference.
Okay. Why don't we do this is we'll reset it in about 30 days and proceed at that point if depending on what's happening.
Okay, very good.
Okay. Thank you. You have a good afternoon.
You too, everyone. Thank you.
Thank you. And we will close the record here.
Well, that's it. That's all. Can you guys believe we've been going almost 2.5? No. Almost 2.5 hours. Guys in the truck. I'm important. Leave me alone. Leave me on the screen, please. God. I really hope that you had a fun night. It was great. We are going to do some fun things. We're going to travel back in time again this week. So we have some fun things coming up. I'm excited. I'm excited. Please keep an eye out. I might even make a video. I'm not going to promise anything, but thanks again to Owen. I've got my bracelet here. It says Owen Hart Paisley. So cute. I love getting things like that. It really brightens my day. Thanks again, MB, Mark, Chris Engleby, all y'all. You guys are all great. And I appreciate each and every one of you so much. Remember, we got street court tomorrow. Whatever the fuck that is, we're going to make it happen. So remember that I love you. I am proud of you. And I will see you in the next video. Bye.